Imagine doing everything right, like raising thousands of dollars, collecting 10,000 verified signatures, jumping through every hoop to run for office, and
And
then
then finding out a single operative from the opposing party can just, well, drag you into a windowless room and legally dismantle your campaign.
exactly, before voters even see your name on a ballot. Welcome to today's deep dive. We are spending our time today unpacking this absolutely staggering narrative from a fascinating 2026 legal brief out of Massachusetts.
Yeah, the case is Michael Walsh versus the State Ballot Law Commission, or the SBLC.
Right, the SBLC. And the mission of this deep dive, what we're really digging into today, is exploring how legal and administrative processes can theoretically be weaponized to keep citizens from having a choice at the ballot box.
It's honestly a masterclass in bureaucratic obstruction. I mean, the brief details the sheer enormity of resources that can allegedly be deployed to block one candidate's access.
It is wild. But before we jump into the weeds here, we really need to set some ground rules for today's discussion.
We definitely do. Because this source material contains some very highly charged political allegations involving both major parties. So we need to make something explicitly clear to you, the listener.
Yes, very clear.
We are not taking sides here, nor are we endorsing these claims as objective truth. Our job today is just to impartially report on the arguments, the claims, and the evidence exactly as they are presented in the candidate's legal filing.
Right. The goal is just to help you understand the mechanics of this specific dispute, how election law functions in these really extreme scenarios.
Exactly. We're just looking at what the brief says.
And I'm really glad we laid that out because, man, the allegations in this filing are intense.
They really are.
So let's start by laying the foundation. Like, how does someone even get on the ballot in Massachusetts?
Well, it's a semi-closed primary system. So if you want to run for statewide office, like Attorney General in this case, you can't just declare your candidacy and walk onto the ballot.
Right. You can't just tweet it out and you're in.
Exactly. You have to actually prove you have baseline support.
Yeah.
The state requires a candidate to submit 10,000 certified signatures from registered voters.
Which, 10,000 signatures sounds like a lot, but the process itself is incredibly labor-intensive too, right?
Oh, absolutely. A campaign has to send volunteers to grocery stores, town dumps, public parks, and they collect these wet ink signatures on physical nomination papers.
Wet ink meaning like an actual pen on paper.
Right, actual pens. And then those papers are physically taken to local town or city clerks across the entire state. Then those local clerks have to manually verify that the signers are actually registered voters in their specific municipality.
Okay, so by the time those signatures make it to the Secretary of State, they've already been vetted by local election officials.
Correct. They've already passed a huge hurdle.
So Michael Walsh, he's running for the Republican nomination for Attorney General. He submitted over 10,000 of these locally certified signatures. On paper, he met the threshold.
He did. But the legal brief outlines that shortly after submitting them, an objection was filed to knock him off the ballot, basically challenging the validity of thousands of those signatures.
Right, and the objector claimed all sorts of issues, right? Ranging from outright fraud to signatures belonging to unregistered voters.
Yeah, and that triggers a formal hearing before the State Ballot Law Commission, which is the administrative body tasked with resolving these specific disputes.
Okay, but this is where I'm looking at the identity of the person who filed the objection, and I need you to explain how this is even legally permissible.
Yeah, it's a big point of contention.
Because the brief states the objector is Adam Roof, who is identified as the executive director of the Democratic Party. How does a registered Democrat, let alone a party official, have legal standing to dictate who gets to run in a Republican primary?
Well, the brief argues very forcefully that he shouldn't have that standing. This is framed not just as like a procedural gripe, but as a profound constitutional issue.
About associational rights, right?
It's exactly. A primary election is fundamentally an internal, intra-party competition. It is the mechanism by which a political party chooses its standard bearer for the general election.
So allowing an opposing party operative to interfere in that internal process, that seems like a direct threat to the party's autonomy.
That's exactly the argument. The filing actually cites a major Supreme Court case, California Democratic Party v. Jones, which dealt specifically with state-enabled interference in primary elections.
Oh, wow. What did the court say?
Basically, the core of the First Amendment right to associate means a political party gets to choose its own nominees
Right.
without interference from rivals.
Makes sense.
Right. So the brief argues that allowing a high-ranking Democratic operative to use state administrative machinery to, displace or delay a Republican nomination goes way beyond ordinary ballot administration.
It frames it as partisan warfare.
Exactly. Designed to deny voters a choice entirely. The logic being, if you can eliminate your opponent before the general election even happens.
You don't have to face them at the polls. That is wild. Okay, so if we accept that this cross-party challenge is the spark of the dispute, the SBLC, the State Ballot Law Commission, is the arena where the fire is fought.
Yes, the referees, basically.
But the filing suggests the referees might not have been neutral. I'm looking at this section detailing the commission members, and it outlines a pretty massive alleged conflict of interest.
Oh, yeah. The filing details the political donation history of the commissioners.
It states that 4 out of the 5 commission members had donated to Democratic candidates, and more specifically, 3 of those members had donated to Andrea Campbell.
And just for context, Andrea Campbell was the incumbent attorney general and Michael Walsh's direct opponent in the upcoming race.
His direct opponent. And the brief even alleges some of these donations occurred while the SBLC proceedings regarding Walsh were actively pending.
Which is highly problematic, according to the brief.
Yeah, I mean, legally speaking, how is a quasi-judicial commission supposed to handle that kind of financial connection to the opposing candidate?
It touches on this bedrock legal concept known as the appearance of justice.
The appearance of justice. Meaning it's not just about actual bias.
Exactly. In the American legal system, it is not merely about whether a judge or a commissioner possesses actual measurable bias in their heart. It's about whether the public and the litigants can trust the integrity of the process.
Because if a tribunal appears hopelessly conflicted, it undermines the legitimacy of everything they do.
Spot on.
Which is why, in a normal court setting, a judge with a financial link to one of the parties would typically step aside. I mean, I would imagine a defendant wouldn't feel great if they found out the jury was actively funding the prosecution's GoFundMe.
That is a great analogy, and it captures the sentiment of the brief perfectly. So when Walsh's legal team discovered these donations, they actually filed a formal motion asking these specific members to recuse themselves from the hearing.
And the brief says the commission just summarily denied that motion.
Yep.
2 of the members apparently submitted unilateral declarations stating they could still be fair, despite the donations, but the filing points out a major flaw with those declarations.
The flaw is that they were entirely self-serving, and they were never subjected to any adversarial testing.
What does that mean, adversarial testing?
Well, in a typical legal proceeding, if someone submits an affidavit claiming impartiality, the opposing counsel gets to cross-examine them.
Oh, I see.
Yeah, they get to probe the nature of the relationship, the timing of the donations, all of that. But here, the SBLC members just sort of police themselves behind closed doors, declare themselves impartial, and move forward.
Unbelievable. And the brief argues this alleged bias really set the tone for a series of severe procedural irregularities.
It really did.
So let's follow that through line. If the discovery process is essentially the preamble to a trial, the phase where both sides gather the evidence they need to build their case, how did this alleged bias actually manifest? Because the brief claims the playing field was tilted immediately.
Well, we can look at how the commission handled interrogatories.
Remind us what those are.
Sure. Interrogatories are formal, written questions that one party sends to the other, and they have to be answered under oath. They are crucial because they prevent what lawyers call trial by ambush. They allow a candidate to know exactly what evidence or witnesses or methodologies the objector plans to use against them.
And so the brief outlines a glaring disparity in how these were handled. It says Adam Roof, the objector, asked the commission for permission to serve interrogatories on a Sunday night.
Right, a Sunday.
And by Monday afternoon, in less than 24 hours, the commission chairman granted that request. Walsh wasn't even given an opportunity to file a formal objection to it.
And look, administrative bodies can move quickly, but a sub-24-hour turnaround over a weekend is highly, highly unusual.
It's even more unusual when you look at what happened to Walsh's team, because a few days later, Walsh files his own motion to serve interrogatories on the objector.
And let me guess, they didn't turn those around in 24 hours.
Not exactly. The brief alleges the clerk literally kept them sitting in a binder for 10 days.
Wow, 10 days.
10 days. And then, right before the hearing was scheduled to start, the commission denied all of Walsh's questions, claiming the request was too late.
I mean, the practical effect of that denial is severe. It meant Walsh was flying completely blind into a hearing regarding the validity of his own campaign.
Right, the filing even notes he wasn't provided the identity of the objector's expert witness until the day before she was scheduled to testify.
Which is incredibly difficult to prepare for.
And this disparity didn't just stop at interrogatories. The brief details a similar situation with subpoenas. Subpoenas being court-ordered demands for documents or testimony.
Right. And how did that play out?
Roof was granted all of his subpoena requests, including one that allowed him to basically mine the Massachusetts Republican Party's internal voter database.
Oh, wow.
Yeah. But when Walsh asked for a single adverse subpoena, just one, for the individual who allegedly mishandled Roof's mailings, the commission denied it.
And the mention of the mailings actually brings up a really critical point regarding administrative jurisdiction. Well, in administrative law, procedural rules and deadlines are historically inflexible, like very strict.
Yeah.
The statute governing these ballot challenges explicitly requires that an objector must send a copy of the objection to the candidate via registered or certified mail.
So it's a strict rule.
It's a strict jurisdictional prerequisite. If you don't do it, you technically don't have a case.
But the brief points out that Roof's team openly admitted they failed to do this. They even submitted an affidavit stating their representative didn't know how to use certified mail at the post office.
They're kidding.
I wish I was. And they also allegedly used a defective voter certificate from the city of Boston that didn't match the required statutory form.
Wow.
So in a normal administrative setting, wouldn't failing to follow strict filing rules get a case thrown out immediately?
Typically, yes.
Mm-hmm.
Courts frequently dismiss cases for minor procedural defects all the time.
But the filing claims the commission just excused these jurisdictional errors for the objector. They reportedly dismissed the certified mail rule as, quote, antiquated.
Wow. So when you synthesize all of this, granting the objector's interrogatories while sitting on the candidates, allowing expansive subpoenas for one side while denying them to the other, and then just waving away mandatory jurisdictional rules,
Right.
the brief argues the commission ceased acting as a neutral arbiter and basically began actively participating in the systematic obstruction of Walsh's candidacy.
It's a really damning picture. So if the discovery process was basically a brick wall for Walsh, how did his team even attempt to defend his signatures once they actually got into the hearing room?
Well, all of this procedural maneuvering leads to the absolute centerpiece of the objector's case, which is the handwriting analysis.
Okay, let's get into that. The objector relied heavily on the testimony of a hired handwriting expert, right, Jennifer Noso.
Right.
And the brief spends a lot of time dissecting her background, because Walsh's team apparently found a recent case from the Ontario Superior Court in Canada where Noso had testified.
And it didn't go well for her, did it?
Not at all. The judge in that Canadian case heavily criticized her credibility. The court found she was evasive, disregarded professional norms, and showed an inexplicable lack of curiosity, basically only analyzing the specific items the hiring attorney instructed her to look at.
Ouch.
Right. So, with that kind of documented judicial reprimand on her record, how is an expert witness allowed to testify in a new proceeding without facing serious scrutiny?
It is a significant hurdle.
Yeah.
And Walsh actually filed a formal written motion to disqualify her based on that Canadian ruling.
And let me guess, the commission denied it.
You guessed it. The brief notes the commission orally denied the motion and subsequently omitted any mention of her documented credibility issues in their final written decision.
They just left it out completely.
Entirely.
Okay, but I want to dig into the actual methodology she used because the details in the filing are just really difficult to wrap my head around.
Yeah, it's pretty technical.
The brief explains that she was forensically comparing the wet ink signatures on Walsh's nomination papers to digital signatures pulled from a registry of motor vehicles database.
Right, the RMV.
And we've all signed those electronic pads at the DMV. They are pixelated, awkward. They rarely look like your natural signature.
Exactly. I can barely read mine when I do it.
Right. So how can you reliably compare a fluid pen and paper signature to a blown-up, low-resolution digital file?
That question cuts to the absolute heart of what is known as the Daubert standard.
Daubert, that's the legal framework, right?
Yes. Daubert is the legal rule judges use to determine if expert testimony is actually rooted in reliable, peer-reviewed science. The judge is supposed to act as a gatekeeper to keep junk science out of the courtroom.
So the brief challenges this.
Aggressively.
Yeah.
The brief challenges the admission of handwriting analysis under this standard, arguing that comparing wet ink to pixelated DMD screens lacks any reliable scientific foundation whatsoever.
Because there are no objective metrics.
Exactly that. There are no established minimum matches required to confirm a signature. There are no objective rules for what constitutes a significant difference, indicative of forgery versus just, natural human variation.
Right, like signing your name while standing up at a grocery store clipboard versus sitting comfortably at a desk. It's going to look different.
Spot on. Furthermore, the field of handwriting analysis just generally lacks reliable statistical error rates.
So the analysis essentially boils down to just the subjective opinion of the examiner.
Pretty much.
But the brief highlights something even more troubling about the specific scale Naso used to evaluate these signatures.
Right. She utilized a standard 9-point scale used in forensic document examination.
And she testified that she found an indication that one writer forged certain batches of signatures. Now, to a layperson, hearing an indication sounds like a pretty solid finding.
It does sound official.
But the brief explains that in the world of forensic document examination, an indication is actually the absolute weakest positive finding on that 9-point scale.
Right. During cross-examination, Natso actually admitted that an indication translates to a probability of less than 50%.
Less than 50%.
Yes. It doesn't even meet the basic civil legal standard of a preponderance of the evidence, which is, more likely than not. It literally signifies that something is possible, but not probable.
Yet the brief claims the commission took that less than probable guess and misrepresented it in their final decision as definitive proof of mass fraud.
Right, they allegedly treated a sub 50% probability as scientific certainty.
Which the filing argues is a material misstatement of the evidence. It suggests that the commission was basically reverse engineering a justification for a predetermined conclusion.
It certainly looks that way based on the brief.
And as questionable as relying on a sub 50% probability might be, the brief details another incident regarding signatures from the town of Scituate that takes this to a whole other level.
Oh, Scituate signatures.
Yeah.
Yeah, this presents perhaps the most unusual procedural anomaly in the entire brief.
So Nasu admitted on the stand that she didn't have any known handwriting exemplars to compare against the over 200 challenged signatures from Scituate.
She literally had nothing to compare them to.
Right. And because she lacked a baseline, she followed her professional code of ethics and made zero findings on those specific signatures.
Which is what you're supposed to do.
So if the objector's own expert couldn't evaluate them, you would assume those signatures would just survive the challenge, right?
You would. The assumption would be that the objector failed to meet their burden of proof.
But the brief states that for the first time in its 136-year history, the SBLC members simply decided to eyeball the signatures themselves.
It's astounding. Without any foundational training in handwriting analysis, they just laid the papers side by side with whatever records they had and disqualified hundreds of signatures on their own.
That's like, I don't know, it's like a judge dismissing the medical examiner in a murder trial and deciding to just eyeball the toxicology report themselves.
It represents a staggering assumption of lay expert authority by an administrative board.
And while they were reportedly acting as their own forensic experts, the brief alleges they were simultaneously ignoring on-the-ground exculpatory evidence.
Yes, specifically the testimony of a man named Paul Burke.
Right. And the context of Burke's testimony is vital to understanding the objector's theory of fraud in this case.
It really is.
Because the objector's theory in certain towns relied heavily on the fact that names on Walsh's nomination papers appeared in the exact same sequential order as a sortable voter database owned by the Republican Party.
Right. They argued the statistical improbability of this occurring naturally meant a forger must have just sat down and copied the list straight down the line.
It was their primary circumstantial evidence of mass forgery.
Yes.
But then Paul Burke takes the stand. He's a disabled, retired Quincy firefighter who has volunteered as a signature collector for 20 years.
A very credible witness.
Oh, exactly. He testifies under oath that he personally spent months at the South Shore Plaza collecting hundreds of signatures. And he explained the database anomaly perfectly.
How so?
He was collecting signatures for 3 conservative candidates simultaneously, so he would ask a voter to sign the paper for candidate A, then candidate B, and finally Michael Walsh.
Consequently, the names would naturally appear in the exact same sequential order across all the different nomination papers.
Exactly, because the same group of voters were signing them in real time, one after the other, at a single location.
It provides a completely logical, innocent explanation for the pattern.
Totally. Burke was a percipient, first-hand witness, providing direct evidence of how the signatures were collected. But how did the commission reconcile his sworn testimony with their theory of fraud?
Well, according to the brief, they didn't.
They didn't.
No. The filing alleges the commission completely ignored Burke's testimony. They reportedly did not discuss it, they didn't address it in their findings of fact, and they made no attempt to explain why they disregarded a sworn first-hand account.
That is just wow. And the brief also notes the commission accidentally shorted Walsh 50 signatures right at the beginning of the process due to a simple arithmetic error.
Just added the totals incorrectly.
Just added them wrong. Unbelievable.
So the legal argument synthesizes all of these elements, right? Ignoring direct exculpatory evidence, assuming unprecedented powers to eyeball signatures, misrepresenting statistical probabilities, and fundamental math errors.
Right, and the brief contends this creates an overwhelming mosaic of administrative bias, demonstrating that the commission prioritized the political goal of ballot removal over rigorous legal standards.
Right. So taking a step back from the weeds of handwriting analysis and discovery motions, why does the minutia of this specific SBLC hearing matter to the broader integrity of elections? Like, for you, the listener, why should you care?
It matters deeply.
Exactly. There are landmark state cases, such as McCarthy and Swift, which clearly establish that once a signature is certified by a local town clerk, it carries a heavy presumption of validity.
Meaning the system assumes the voter's intent is valid unless proven otherwise.
Yes, the burden of proof rests entirely on the objector. They must prove, beyond a substantial doubt, that the signature is invalid.
Substantial doubt.
Right. The courts have repeatedly emphasized that the primary object of election laws is to secure the rights of qualified voters, not to defeat them with technical administrative obstructions.
But the brief argues the SBLC fundamentally inverted this standard. Instead of giving the benefit of the doubt to the enfranchisement of the voter, they handed the benefit of the doubt to the partisan objector.
Right. They allowed pixelated DMV signatures, sub-50% probabilities, and their own untrained visual comparisons to override the presumption of validity created by local town clerks.
And the overarching narrative presented in the source material suggests a profound misuse of authority. It basically details a state apparatus allowing a partisan actor to successfully dismantle a rival party's ballot access.
It really does.
It is a heavy, dense topic, but it sheds light on a part of the political process that rarely gets mainstream attention. We've covered a massive amount of ground today, looking at how discovery processes can be heavily tilted, how financial conflicts of interest can taint the appearance of a fair hearing, and how subjective forensic methods can be deployed to invalidate the choices of everyday citizens.
It really requires a shift in perspective regarding where political battles are actually fought and won. And, I want to leave you with a final thought to ponder as we conclude our analysis of this legal brief.
Okay.
Consider the sheer enormity of resources detailed in this filing.
I mean, the legal fees, the expert witnesses, the time spent fighting subpoenas.
Exactly. If the bureaucratic barrier simply to appear on a primary ballot requires a massive legal defense fund, navigating constantly shifting procedural rules, and fighting a state apparatus that seemingly acts as both a referee and an opposing player who is actually capable of running for public office in this country.
That is a really unsettling question.
Right. We are so conditioned to believe that elections happen in voting booths on a Tuesday in November. But the narrative in this brief forces us to ask, is the real election actually being decided months earlier, behind closed doors, in windowless administrative hearing rooms?
That is definitely a perspective-shifting question to end on. Thank you for diving deep with us today. We'll catch you on the next one.